What if a buyer of real estate dies after the purchase contract is fully executed, but prior to the close of escrow? So we've previously talked about what happens if a seller dies. And in this case, what happens if the buyer dies? So in the prior show, I discussed that if the seller dies, that the contract is still enforceable as to the seller's estate. But in this case, what happens if the roles are reversed and the seller is still alive, but the buyer has died? So what happens if the buyer's died? You have a purchase contract, but there's been no close of escrow. In that case, the contract is no more. You cannot force the buyer's heirs or the estate to perform under the purchase contract. Instead, the purchase contract goes away and the parties are no longer in any form of obligation. However, the buyer's estate could still perform on the contract. So when I say it's no more, I mean it's no more as to the buyer, but it is still could be enforced by the buyer's estate as to the seller. So that is what we call a voidable contract, meaning there's one party to the contract that has the right to void it, and it's not the seller. It's the buyer's estate that would have the right to void the contract, to declare the contract to be no more, to declare it unenforceable. But if they so choose, and there could be circumstances where the estate does choose to enforce it, they can enforce it against the seller. So the seller basically has to kind of wait and see what the buyer's estate is going to do. And the ball is in their court, and they make the decision whether to enforce the contract or to let the contract go. So what happens if a buyer dies before the close of escrow? The answer is it becomes a voidable contract, and the buyer's estate can either void the contract or they can choose to enforce it.